federal judge out of New York has blocked a Trump administration rule. The rule was called Protecting Statutory Conscience Rights in Healthcare with Delegation of Authority. The rule would have essentially allowed medical workers to deny services based on their own personal religious beliefs. U.S. District Judge Paul Engelmayer of Manhattan said that the court has vacated the U.S. Department of Health and Human Services 2019 rule in its entirety. He called the rule unconstitutional. The decision that he issued was over 147 pages. He gave a number of reasons of why he found it unconstitutional and called it arbitrary and capricious as well. He says that the rule actually conflicts with federal laws that govern the obligation of employers to accommodate workers' religious views and hospitals to provide emergency treatment to patients, especially low-income patients. Now, this is another example of a court striking down a rule or proclamation out of the Trump administration because it conflicts with federal laws that are already on the books. It's a violation of the Administrative Procedures Act, according to this New York judge, to do such a thing. Now, this lawsuit was brought by the state of New York. It was joined by 22 other either states or municipalities or health organizations. This opinion and order essentially consolidates 3 separate sets of plaintiffs, and it blocks the rule from taking effect. This would have gone into effect at the end of November, around November 22nd. This was delayed. If you've been following this action, it originally was supposed to take effect at the end of July. It was postponed, and now this final order has been made. This all started back when President Trump signed an executive order in May of 2017 instructing the Department of Health and Human Services to find ways to make this religious and moral objection possible. The Department of Health and Human Services followed by issuing this rule, what is essentially interpreted and provided for the implementation of what ended up being over 30 statutory provisions. It all centered on that recognition of the right of an individual or an entity to abstain from medical procedures, programs, services, or research on account of moral or religious objection. It essentially widened the type of person that could make such an objection. Now, the rule also provided for more enforcement and punishment if a facility didn't allow for an objection. So say a medical worker inside of a hospital wanted to make an objection and the hospital said, no, you can't, you have to treat this patient. The original rule would penalize the hospital for not letting that medical worker object. And one of the biggest penalties on the table was losing federal funding for that facility. And the judge in New York had a lot to say about that. Now, there were comments coming out of the New York Attorney General's office, one of the plaintiffs in the suit, calling the rule as it stood, the religious objection rule, as an unlawful attempt to allow healthcare providers to openly discriminate and refuse to provide necessary healthcare services to patients. Now, there were a lot of comments. This was a rule, so there was a public comment period. They got over 200,000 public comments, and generally, even people that held very firmly to their own religious beliefs agreed that it was not good practice to allow a medical worker to decide which patients they wanted to treat and which ones they didn't. There was consensus that if you are going into the emergency room as a patient, you would rely on that facility to serve you. Now, what's next? The federal government can certainly appeal. This was the district court in New York that gave this ruling and order. The other thing to keep clear is that this is distinct from another set of lawsuits and rules that is working its way through the courts right now that talk about discrimination in healthcare, but those are on gender identity grounds, and that is a distinct lawsuit from this moral and religious objection suit. So keep those two separate. We do have separate videos on what was called that 1557 rule that is also in litigation. We link to the opinion and order in the description below, but as it works its way through the court, we will keep you posted. Make sure to like this video and subscribe so you can stay current on that.